the event. And I will stop sharing my screen so that we have a view of the panelists instead of our slide deck. Okay, terrific. I think we're at a good number. If you agree, I think we'll start. Deborah, are you okay with that?
Yes, that's fine. Thank you.
All right, terrific. Well, good evening, everyone. Welcome to How Do You Know Who Did It and Then What? The Challenges of Cyber Accountability. This is a webinar organized jointly by the Washington Foreign Law Society and by the Stimson Center. I am Michael Todori, president here at the Washington Foreign Law Society. The Washington Foreign Law Society was founded in 1952 to promote knowledge and understanding of international legal matters, comparative legal issues, and foreign law. It serves as a forum for discussion among legal and non-legal professionals serving in public and private capacities with a range of stakeholders, including U.S. government agencies, foreign missions, NGOs, academic institutions, and many others. Our co-host today is the Stimson Center. For 3 decades, Stimson has been a leading voice on urgent global issues. Today, as changes in power and technology usher in a challenging new era, Stimson is at the forefront, engaging new voices, generating innovating ideas and analysis, and building solutions to promote international security, prosperity, and justice. This is the 5th in a series of events that the Washington Foreign Law Society and Stimson have jointly produced to examine and discuss legal accountability in cyberspace. If you haven't followed prior events, I do encourage you to go on the WFLS website. That's WFLS.org to take a look. All the videos are up. You can watch the recordings as you please. They were truly all excellent, so go take a look if you're interested. Today's event will be moderated by the fantastic Deborah Decker. Deborah is a board member here at the Washington Foreign Law Society and is a senior advisor at Stimson, and truthfully the real engine behind all of our cyber programming over the past year. Let me provide a couple of housekeeping notes before I let Deborah introduce our distinguished panelists. Participants will be muted during the webinar, but you will be able to communicate with us via the Q&A section. Please send any questions to our panelists using the Q&A feature on your screen, and we'll get to the questions at the end of the session, and we already have a good number of questions from attendees who registered in advance. As a reminder to everyone, the session will be recorded and is being recorded. As I mentioned, prior recordings of other events are available on our website, so go there and check them out. And finally, don't forget to follow us on Twitter. Our handle is @WFLS1952 and on LinkedIn. And one final note before I leave it to Deborah, please consider becoming a member of the Society. There's a discounted rate for students and government nonprofit employees, and I'll be putting the link on the chat while the other panelists are speaking. With that being said, Deborah, take it away.
Thank you so much, Michael, and thank you to our panelists for joining us and to all of our attendees. I want to first introduce, I'm going to speak quickly because there's so much to cover, Dmitri Alperovitch. He's executive chairman at Silverado, Policy Accelerator, co-founder and former chief technology officer at CrowdStrike, board member of Automox, Dragos, and other organizations. And Dmitri, I see you all over the place. I mean, in the news with your very well thought out opinions, testifying to Congress, and even starting a new institute at Johns Hopkins University. It wasn't in the online bio we posted. So I wanted to please take a moment to tell us first about this wonderful new educational institution initiative at Hopkins School of Advanced International Studies, and then also a little about Silverado, which is also pretty new.
Thank you so much, Deborah. Great to be with you. So a couple of initiatives that we launched this year. One is Silverado Policy Accelerator, a new nonprofit here in DC that's focused on accelerating policy in 3 specific areas: cybersecurity, trade and industrial security, and what we're calling EcoSec, the intersection between economic and ecological security. The broad theme is how do we ensure American prosperity and competitiveness in this century, particularly in the new era of great power competition and the challenges that the rise of China poses. And certainly China poses tremendous challenges in all the 3 areas that we are working on: cyber, trade, and environment. And the goal is really to dive into the details and to work with policymakers here in DC, in the executive branch and legislative branch, to try to come up with specific proposals that can get this country into a better place on these issues. So we're working on things like semiconductor supply chain issues. We're working on climate change related carbon border adjustments issues. We're working on cyber breach notification, and reorganization of federal government for success on cyber issues. So a wide variety of projects going on. So that's one project that we have. And then the second organization that you just mentioned, the Alperovitch Institute, that we launched last month at SAIS, at Johns Hopkins SAIS, is a great academic institution that will focus on building up workforce in cybersecurity policy. So we will, starting next fall, have master's students that will be studying cybersecurity policy. We'll have a cohort of PhD students, fully funded, working to provide sort of the next generation of professors in this field to make it sustainable. And then we'll also have a short executive education program, probably around 8 days, to bring senior leaders from private sector and government together to deep dive into these issues and teach them what they need to know when it comes to cyber strategy. So application deadlines are December 15th for the MA program and the PhD program, and stay tuned for more information on the exec ed program that we'll put out later this year.
Thank you for all you do. It's fantastic. It's not siloing people. It's getting the broad mix of cyber technology and policy. So thank you. And now we have Dr. Else de Busser. She's an assistant professor of cybersecurity governance at the Institute of Security and Global Affairs at Leiden University in the Netherlands. She co-wrote a really interesting piece on the legal challenges to attribution in cyberspace. I've read it 3 times, and there's a link to that on the registration page. And she's also a researcher with the Hague Program for Cyber Norms. So welcome, Else, and please take a moment to tell us more about you and the Hague Program. And there's a big conference you're starting next week.
Yes, thank you so much for that introduction, Deborah. And thank you so much to the Stimson Center and the Washington Foreign Law Society for having me on this panel. So indeed, I'm a part of the Hague Program for Cyber Norms, which has been working on the topic of development and implementation of norms on unacceptable behavior in cyberspace for a number of years now. We try to focus on how consensus is built, and we try to contribute to that dialogue by publishing policy papers like the one you just mentioned that was focused on attribution, but we also write academic papers. We publish in academic journals. And indeed, next week we have our annual conference, which in this time is appropriately focused on governance of crises multiple, but of course, with the main topic being cyber crises.
Well, I registered for it. It starts like at 3 a.m. my time. However, will it be recorded so I can tune in later or not?
Yes,
okay.
That will be recorded.
Okay, so I can sleep through the morning, and it's free. And maybe we can add that when there will be a YouTube link and a posting of this later with some of the links to the things that we've discussed. Yes. So I want to start with, I don't have to go into cyber attacks. We all know how hard that it is, but we're talking about attribution. Let's start with a definition of that and its purpose. So, Else, from a legal perspective, I mean, can you give us briefly that?
Right, so attribution as a concept, I know that sometimes in national criminal law, it is not that often used, but everybody will know it as the who did it question. Who is responsible for a specific act? And when we use it in a cybersecurity context, that is also exactly what it means. It just gets a little bit more difficult because of the way that cyber incidents can happen. And I specifically say incidents, but we're mostly talking about criminal acts by individuals, by non-state actors, but also by what we usually refer to as cyber attacks, which is when a state actor is behind it. Now with attribution, and that is where the difficulty lies, is in the fact that you can have a technical attribution, which is often done by private companies, but also by public authorities. You can have, however, also a criminal prosecution. So then you have a criminal law approach to attribution, but you can also have attribution in a political way. You can even have attribution by media. So in fact, attribution is really pointing the finger at one specific perpetrator or group of perpetrators. When speaking of the purpose, I think we need to point out that in cybersecurity, especially with, I just mentioned cyber norms, what is acceptable behavior in cyberspace, we think the purpose of attribution is really pointing out when somebody has crossed a line. Because in state behavior in cyberspace, those lines are not as crystal clear as you would expect them, or as you see them in a criminal code, for example, for normal traditional criminal acts. And that the difficulty lies in where is exactly the threshold. You can compare it to if you drive your car on a road where you're allowed to go 50 miles per hour, but you know that police is only going to catch you on their radar at 58 miles per hour, you're going to drive 57. Maybe you're even trying to get to 57 and a half, as long as you don't hit that specific threshold where you can actually expect a response. And that is something that we really need to take into account when speaking of attribution. And that's how I think that you could define attribution as confirming a norm, confirming where the line is, where do we draw the line. Some also say that attribution is or leads to at least to avoiding impunity, to make sure that people don't get away with what they are doing. But I want to stress here that avoiding impunity can only be named as a purpose of attribution when it goes hand in hand with consequences. So if there are no consequences accompanying the attribution, I think the avoiding impunity cannot be highlighted as a purpose.
Dmitri, do you need to add anything to that, or can I jump into how hard it is to know? Okay. So to that point, how hard is it to know who is responsible for a cyber incident? Do you actually know who does that work, and how does it get verified? And you certainly know this stuff.
Right. Well, certainly there's a range of parties that are doing attribution. Certainly you have the government, various governments doing attribution, the intelligence communities that are constantly doing assessments on major attacks of national consequence. You have law enforcement agencies that are prosecuting both cybercrime and espionage acts being committed by foreign governments. And you have private companies that are doing this on a regular basis because anytime they come in to help a victim investigating an attack, the first question they typically get asked by an executive is, okay, someone came in and stole some data, who did it and why did they do it? And there's a hunger for understanding that information. The way attribution is done is actually not that different from the way that crime is being solved in regular sort of physical world space. You look at all the details, the forensic details of what you've accomplished. You look at any intelligence you may have in terms of maybe insight you have into the adversary. So one way, for example, that intelligence agencies may know that a foreign government is doing an operation is because they have spies inside that intelligence agency that may tell them, or they have other means of listening into what is going on to get insights into their operations. But even in the absence of that, you can certainly do attribution by doing what the police and the FBI do when they investigate bank robberies. So when they come in and arrive on the scene of a bank robbery, they don't say, well, if there's no tracks from the getaway car that lead us directly to the robber's house, there's no way that we could possibly know who did it, right? They look at how the robbery was conducted. Does it match any of the previous robberies they've seen in the area? Maybe they have a fingerprint that they were able to collect from prior robbery that they can connect through other means to this one robbery, and build a chain of evidence over a course of time that will point you to the gang that's perpetrating these bank robberies. And it works the exact same way in cyberspace, where you don't look at each intrusion in isolation. Typically for major hacks, the actors that are doing them, this is not their first operation. They've probably been doing operations for decades. So if you're able to link them all together, the first time you see them, you may not know who did it, but the 10th time, the 100th time you see them, you'll have a pretty good idea because you've accumulated so much evidence about their operations, and inevitably, because they're being done by humans. Humans are not perfect, they make mistakes. And in each operation, they may reveal a little bit about themselves. And when you put it all together, the puzzle pieces start fitting in. And that's why attribution has only got easier over time as you see more and more activity from these major criminal groups, from these major states, because once they start doing it, of course, they're going to keep doing it. Once they've invested in the capability, build it up, train the people, you're not going to use it one time and shut it down. You're going to use it on a daily basis. And as a result, you're going to produce more digital exhaust that's going to be useful for investigators to keep collecting. And ironically, we lament in personal lives that we have less and less privacy online, that the big tech companies and others are collecting so much information about them. The one positive in all of that collection is that it makes it easier to do attribution, because the adversaries are also impacted by all this collection that's taking place.
I was just watching the HBO documentary, The Perfect Weapon, and you told an interesting story of how CrowdStrike tracked down the infiltrator of a solar panels company. I mean, was that, and you didn't go into why they wanted to know, but I was talking to the Cyber Threat Alliance, and they were saying that they didn't need, that a lot of, when they alert companies to an event, that they don't need to tell who did it, because the company just wants to know, like, I just need to, shut this down. I've been broken into. In that case, though, you were looking into who did it, because was that an IP case? I don't know if you remember it. It was probably recorded a while back.
Yeah, I mean, it all depends on who you're talking to, right? So, you often hear this in the industry that, cybersecurity professionals don't need to know who did it. And that's true. Like if you're working with an operator of a SOC, Security Operations Center, they may not be very interested in attribution. They may not need to know attribution, but I can tell you, if you're talking to the executives at a company, if you're talking to the CEO and describing a major breach that's occurred, that's going to be the first question that they're going to ask you. So this debate of do they need to know or not need to know usually comes down to at what level of the organization are you talking to, and if you're dealing with a board, if you're dealing with executives, they don't care about the technical details. They care about the implications to the business, and for that, they need to know who did it.
Is attribution easier or harder to do by type of incident? An espionage, and what about false flags? Because
so false flags are really hypothetical. We have not seen successful false flags operations. They're actually really, really hard to do. To emulate everything about a specific adversary down to their tradecraft, down to their infrastructure is really, really hard to do. So we've seen a few cases. One of the most famous ones was during the Olympic destroyer case, a malware attack, a wiper attack on the Olympics in South Korea in 2018 that was conducted by the Russian intelligence services in response to the International Olympic Committee banning Russian athletes from participating due to the doping cases that they had seen in the Sochi Olympics. And they try to do crude false flag operations where they try to put markers in the malware that made it look like the malware was developed by the North Koreans, but no one in the industry fell for that. It was very obviously a crude false flag. And the thing that often helps with attribution, it's not definitive, but it's often sort of the first thing that the investigators look for is the cui bono, who benefits from that. And if you look at the Olympic destroyer case, it made no sense for North Korea to attack the Olympics, because at the time, if you recall, the North Koreans were on a charm offensive. The sister of Kim Jong-un was actually there at the opening ceremony, being chummy with the South Korean leadership. They were trying to restore ties at the time. So it made no sense for why the North Koreans would launch an attack. And it made perfect sense that Russia would do so, because they were the only country not participating officially in the Olympics. So that was the first clue. And of course, there were many other technical details that led my firm CrowdStrike at the time and many others to conclude with high degree of confidence that it was actually the GRU, the Russian intelligence service, military intelligence service, that was responsible.
Well, I'm glad you mentioned with high confidence, because that was one of my questions about, we don't always talk about confidence levels. Else, in your paper, that you talk about how much evidence is enough. The International Court of Justice, clear and convincing standards, criminal justice systems beyond a reasonable doubt threshold for Anglo-Saxon criminal justice systems. But whereas the continental criminal justice systems, intimate in-time conviction or reasonable certainty of the judge. Could you speak a little bit about some of the legal standards for attribution and some of the distinctions and under the different legal regimes?
So the red thread throughout that paper was actually that we defined 3 tails of attribution, we called it. So 3 different paths. One is, of course, we just mentioned criminal acts, and one is clearly criminal prosecution. So you can actually, especially when a company is hit, I can imagine that the first call that they make will be to law enforcement or to the cybersecurity professionals to stop an attack. And so criminal prosecution seems to be a rather clear path. And we have to point out here that criminal prosecution is, of course, for non-state actors, it's for individuals. You cannot indict a state and bring them before a criminal court. But we also have to point out that when you're talking about criminal prosecution, you're talking about very high evidentiary standards. You're talking about several mechanisms that are put into criminal proceedings in order to safeguard the integrity of the procedure. We're talking about independence, we're talking about impartiality, due process, fair trial rights. Those mechanisms, protective mechanism, the integrity of that proceeding, and the high evidentiary standards we do not see in the 2 other paths of attribution, which is international law and policy. Because in international law, then we're talking about state actors, of course. We're talking about not specifically individuals, but state actors. Have to mention here the gray zone between state actors and non-state actors, because states can also be clever enough to use individuals for these carrying out these types of attacks, whether or not being employed by the state, whether or not being endorsed or simply tolerated by the state. But essentially, international law is a matter between states. And that is where we don't see this step-by-step prosecution phase before a response happens. And we don't see that in policy. When policymakers look at a cyber attack, they are framing it as a political problem, because other interests are at stake here. And certainly when attribution happens at this level, in a political way, you have quite some different interests at stake, meaning the geopolitical situation is clearly a big factor here. A small state, for example, will be very reluctant to attribute, to point the finger at a bigger state out of fear for what is coming back at them. Which is also one of the reasons why you often see attribution in coalition, where groups of state attribute at the same time. Strength in numbers, we could say here. Other interests are also at stake in these different paths from criminal prosecution, in that sense that the line that has been crossed will not be so specific. I mentioned criminal codes before. If you look at a criminal act being defined in a criminal code, that will be very specific. Whereas in international law, the attribution will often, especially if we look back at older cyber attacks, we will be often put into a general statement, this was a violation of international law, without saying specifically which rule. And that vagueness is there for a reason. But also when policymakers when a political attribution is made, we also have to think that this a big factor in that is the capabilities, the technical capabilities of the state.
To be able to do that. So as you point out, some smaller states are not able to. As an aside, I want to just ask you, you know, the US has the Foreign Sovereign Immunities Act, but there are holes that they put exceptions into that act for international legal norms that would not provide immunity for if you are a state sponsor of terrorism. And that caused in US courts to have cases against Libya and Iran, and the Libya ones were settled by Gaddafi when he gave up his weapons of mass destruction. But the Iran ones are still outstanding and could cause a problem. I don't know about other countries that may have some exceptions. Michael, I don't know if you as another lawyer in that area might jump in, but it's a whole separate area of taking it away from states for attribution and for finding some compensation. But maybe we can save that for another time. But I do want to throw that out there because I think it's a really interesting way. But given ransomware, then we know that a state-sponsored actor or a state-aligned actor may have done it. You know, what can we do? You touched on this point on that I really wanted to emphasize that you talked about in your paper too, that let me find it here. you said that states, even in the most recent cases of attacks, states use only opaque references to undermining like sovereignty as a political term rather than international law concept. Ironically, this makes the application of international law and ending impunity in cyberspace more difficult. The absence of references to international law in existing accusation diminishes the value of that law as an instrument aimed at preventing conflict. Or formulated more positively, if states do attribute with reference to international law, it will contribute to general practice accepted as law that may contribute to the formation of customary international law. I mean, so one of the things is states need to be saying, this is wrong, here's my line, this is how it fits in international law. Is that right? Is that the simple explanation?
Yes, but also the vagueness and the ambiguity serves them well sometimes, because the more specific, the more precise you are, the stronger your evidence will have to be. And if the evidence is difficult to receive—
Well, Dmitri can provide the evidence.
Sorry?
Dmitri can provide the evidence. I mean, you know, actually that is something that Stimson's going to be looking at in some of the research that we're doing is, you know, comparable areas like the International Atomic Energy Agency or others, like, are there groups of actors that could come together to help provide the evidence for some of the statements that could be supportive of international law? Again, you know, we think far in advance. This is not something that's going to happen tomorrow, just like it, but.
Well, I've heard some arguments going for creating an OPCW for cyber attacks, which I'm just around the corner from the OPCW here in The Hague, which would actually be an interesting way of thinking it, that you have an investigative service almost in order to work up the evidence. But that is really a story for a different day, actually.
Yeah. Although that's the way I'd like to see it headed. You say in your paper also that the attribution of attack to the territory of a state gives the victim state the right to request assistance or compensation from the state. It's not unreasonable to expect such requests should be responded to in good faith and in the spirit of cooperation between states. Should such efforts fail and malicious intent to the other state become clear, potential punishment could ensue. So what norms, laws, or agreements are you referring to when you say that they have the right to request compensation?
Well, I'm talking here about the right to ask for assistance, so mutual legal assistance in general, and the traditional mutual legal assistance that we see between states, that you see in multilateral conventions, that you also see in the context of cyber attacks in the UN GGE norms. You see international cooperation being strongly put into a norm here. That states actually have to give each other assistance in order to find evidence, in order to strengthen the investigation.
So how do you think these norms and application of laws can be strengthened?
Well, that's the problem with norms. Norms are non-binding, and so if you get states together and you make the trust grow between states, you can also try and convince them to implement it. But I have to say, in international law, that is something where consensus on the application of it is quite difficult. And the same goes with norms, that there's not always consensus between states on how to do this particularly.
You mentioned the UN GGE, the governmental group of experts on advancing responsible state behavior in cyberspace in the context of international security. So the norms that came out of 2015 that are being reiterated, one of the norms states that states should not knowingly allow their territory to be used for internationally wrongful acts using information and communications technology. But we know that happens. So let me switch now to Dmitri, because let's go back to the attribution and level of evidence needed. There was a piece earlier this week in the New York Times where Ann Neuberger, the Deputy National Security Advisor for Cyber and Emerging Technologies, had some virtual meetings with her counterpart in Moscow, and the US turned over names and other details of a few hackers actively launching attacks. Do you have any predictions on how this might go, what level of cooperation there might be? This is in the context also of the US and Russia apparently preparing some, I don't know what it is, joint resolution to present to the UN on cyber this month.
Yeah, I'm not very optimistic that anything will come out of it. I think that the longer we get away from the Geneva summit, that I thought was a very important summit between President Biden and President Putin, on this issue, the less likely it is that Russia is going to cooperate. If we didn't see immediate cooperation, post the summit, the longer we get away from it, the less likely we're going to see it, because the pressure just dissipates. And it's pretty clear that the administration has not been willing to make serious threats of Russia, as Matthew Rojansky of the Wilson Center and I have proposed in several op-eds in the Washington Post earlier this summer, that if Russia does not collaborate and cooperate on investigations and prosecutions of these criminals, that we argue they should incur severe sanctions on their oil and gas sector. Those threats did not materialize, and as a result, I think the Russians have very little incentive to do anything.
In that same article, you pointedly, it was pointedly noted that Russia was not affected by the sanctions put on by SolarWinds hack, as Microsoft revealed recently, that there was this new effort to get into cloud services and infiltrate thousands of American governments and corporations. You were quoted as calling this a tactical direction shift, not a one-off operation. Could you explain more about what you meant with the Russians doing this?
Well, I actually think that the sanctions on Russia for SolarWinds were a mistake, because SolarWinds was actually the one operation that I think does not fall outside the norms. It was an espionage operation. The Russians were doing what the Russians have been doing for almost 100 years, which is breaking into the Department of Justice, breaking into the Department of Treasury, Department of Homeland Security, and other government agencies to steal secrets. That's what intelligence agencies do. That's what they've always done. That's what they will always continue to do. That's what the U.S. intelligence community does. So setting a norm that we're going to sanction Russia for doing that, I think is counterproductive, frankly, because it just sends the message to the Russians that we're going to sanction no matter what they do, even if what they do is exactly what the U.S. is doing, and you're not going to deter any activity from them as a result. And obviously, it has not worked. It was not expected to work. So what I meant in that particular quote from the New York Times is that the tactical shift that the Russian intelligence community has made in the last few years is to realize that instead of targeting individual organizations, individual government agencies that they want to get into, or companies, that they can go after the supply chain companies. They can go after IT companies like SolarWinds, Microsoft, and others to then get to their customers. So you have this sort of single entry point because of the concentration of customers that are using these infrastructure organizations, so that if you get into their front door, you can now get access to all of their customers, and you can pick and choose which ones you want to get into. So that's what I was referring to there.
So what's the reason they want to get in? Is it part of mutually assured destruction? I'm in your energy company, you're in mine, or is it like I need your IP?
It's to steal secrets. That's the vast majority of the attacks are being conducted by the Russian government. They're doing espionage, traditional espionage, stealing government secrets, stealing other national security-related secrets. They're also doing some economic espionage, stealing IP, stealing trade secrets, although they're a much smaller player in that realm than China, which is by far the biggest perpetrator of economic espionage. And they're also doing some disruptive attacks. They're famously doing, of course, election interference. They've done it in the past, at least. They've done some coercive attacks on Ukraine to shut down their power, to mess with their elections, and so forth. But those are fairly rare. The vast majority of the attacks are just simply theft.
So
from the state.
Yes, please, Else, jump in.
Yeah, I want to make a remark here, because when we're talking about digital espionage, this is the murkiest of territories that there is in international law, and especially where exactly the line is that where it is unlawful, where it is intolerable, is still unclear. But what struck me in the White House statement on the SolarWinds incident is that, and this is where statements by government officials, by White House, by sometimes even speeches by government officials can really help in making it clear where the line is that can be crossed into unlawful espionage. What struck me in the White House statement is that they actually gave a multi-factor test for responding to cyber incidents. So it gives us a little bit of an insight in the reasoning of when should we respond to espionage, when can we tolerate it, when can we no longer tolerate it. And if you look at the factors, I'm just looking at my notes here, it includes scope of the incident, the burden on the private sector, something that Dmitri already mentioned, the history of the perpetrator causing disruptive cyber operations, and this I thought was interesting, the risk to the global supply chain and the theft of red team tools, which makes me think that there's maybe some kind of risk-based approach developing in whether or not digital espionage can be tolerated, yes or no.
Well, it's an interesting, that was interesting way to frame it, because it's not just, is it espionage and is it allowable, but is it to such extent, and the theft of tools. I mean, that, you know, well, I'm looking at the comparison. I've worked in the past in the nuclear sector, and you're responsible for the operator's responsible for keeping his nuclear material, or his, you know, his sole responsibility. And, you know, the loss of the theft of the NSA tools to begin with led to so much havoc in the world with, I mean, what responsibility do countries have for protecting their own tools, and do they have any liability when those things get out?
I think that the shift is now going from is there clear and present damage to what is the likelihood of damage, and that's I think an important shift.
Do you think that, you know, for both of you, I mean, as we develop, as countries develop more tools, and I think it was the Carnegie or CFR said that there are like 50 countries that now have indicated that they have cyber tools for that are, you know, not just defensive, but are also offensive. What is, you know, when you're talking about where the line is and the likelihood, or do they have responsibilities for if those tools get out? And we know that it was, they developed the tools, and they're like Stuxnet, right? And now there's this tool that happened that you can, you know, change some code and apply it elsewhere. I don't know, Dmitri, do you feel that there's any responsibility?
Yeah, honestly, I think it's a red herring. First of all, the 50 number is wildly off because it's pretty much every state now that has that capability, either developed indigenously or bought easily from companies like NSO in Israel and many others that are selling it to almost anyone who's willing to buy and has a few shekels to their name. So that has become, you know, the genie's out of the bottle. Everyone has a capability. In terms of the spread of those tools, the impact of that is really minimal. I mean, Stuxnet has been out there, as you mentioned, since 2009. It has not been reused by anyone.
Oh, really?
The idea that, you know, just because a piece of malware is out there, you're going to have, you know, a lot of those dire predictions were made that now we're going to have nuclear reactors and hospitals and all kinds of other infrastructure going out offline. Of course, none of those predictions came true. Adapting malware is actually very, very difficult. Adapting exploits is a different situation. So the famous Eternal Blue exploit, allegedly stolen from the NSA, has been reused, but you know, once it's patched, it's no longer as viable because you basically mitigate its protection. So it's really not as big of a deal as people think. And the other reason why exploits don't matter as much is they're, for all intents and purposes, infinite. If Eternal Blue didn't exist, there would be something else to take its place. So we should not assume that, you know, if you know, that exploit had not leaked, that we would be magically more secure. We just wouldn't be.
So before we go to the questions, I just want to do some takeaways. I mean, for me, it's having states be clear about where the line is, and having them cite potentially international law and norms in order to bolster it. Again, I'm coming from my nuclear, you know, sphere, and stating that, and then, but the only thing that's happening next is some criminal prosecutions by the FBI of individual actors, which I don't know, and some sanctions that may or may not have marginal value. So, you know, keep stating it, but I don't know what to do next. Okay. Any else? Do you want to do a takeaway from like what do you suggest? How can we take this forward?
Well, my colleagues and I have also been studying previous cyber attacks and trying to study them from the shift that is happening in international law and in norms. So from the idea of if they would happen today, would the reaction be different? And we actually saw that, just like I mentioned the White House statement as a response to the SolarWinds hack, more and more states are giving indications on how international law should be applied. And more states are actually doing these public attributions referring to international law. It's still rare that they define the specific rule that has been broken, but we see a shift happening. And I do think one of the big factors in this is the open-ended working group and the fact that the deliberations of the open-ended working group are available, are accessible. So you see actually the deliberations in the chair's summary, which were the points where there was no consensus on. You can read them and you can see what the reasoning behind is. And I think that helps the debate forward.
Okay, we'll put that in the links that we add later on. And to that point, I'm going to suggest to Unidir that the research arm that's supporting those deliberations in their cyber policy portal, they have all the policies of different groups of different states, that they maybe add another subsection that says attribution and citations to international law. I wonder how hard that would be. Maybe that could help us. Okay, Dmitri, any last thoughts or takeaways before we go to questions?
Well, I think we need to focus on what we really care about. We have to separate traditional espionage. That's been going on for thousands of years. It will continue to go on for thousands of years. We're not going to stop it. We're not willing to obviously stop it ourselves. So that's not a norm that we're willing to enforce or we can ever enforce. I think the intellectual property theft, economic espionage, we can make a dent on because it is basically economic warfare that's being perpetrated against our country. And we have a variety of means to respond to that in the economic sphere. The Trump administration famously used the 301 investigation to raise tariffs on China in response to the IP theft that they've been engaged in for the last 20 years. And then when it comes to disruptive attacks, like the ransomware operations that are being conducted by criminals that are being harbored by countries like Russia, those are now becoming a key national security issue. When our hospitals are going down, the famous case that some of your viewers may have read about, a baby dying in Alabama, a newborn, because the hospital suffered a ransom attack that took down the monitors and the nursing stations, and they didn't have enough procedures in place to respond to it and sort of go on manual monitoring mode, and the baby suffocated. Very tragic case. When those things start to occur on a regular basis, when hacks like Colonial start to occur, that becomes untenable for a state to endure, and all options are going to be on the table to respond to such an activity. And we're going to go back to sort of the Bush doctrine. If you're harboring terrorists, you're going to be treated as one. I think we're in danger of getting close to treating countries that harbor ransomware criminals in the same fashion.
Thank you. Well put. Michael, I know we had a lot of questions before we started. You want to pose some of those now?
So many questions. Thank you to all those who posed the questions. One point I wanted can anybody hear me? I think I froze it for a moment. No. One point I wanted to go back to that was raised earlier was a relationship between the need to increase tools for attribution and the growing push for privacy and encryption on the web, right? So obviously there's some tension there between these two facets, and I'm curious from both Dmitri and Els, how do we think of this dichotomy from an industry perspective and from a legal perspective? And I think Dmitri, I see you nodding. You can go first, and then perhaps Els as well.
Well, I think this is one of the key issues that is not being recognized in the EU regulatory frameworks, is that privacy and security are not the same thing. Sometimes they are, without security, you don't have privacy, but with privacy, you may not necessarily get security. And, the frameworks like Gdpr have, unfortunately, in my estimation, lowered security because of the onerous implications that law has put on security companies in terms of their ability to collect information that is necessary for defense and attribution. So we need to make sure that, as regulatory frameworks emerge around the world for greater privacy, which I'm certainly in favor of, that we're taking into account the very critical implications for security, both in cyberspace and frankly in the physical world, where those tensions emerge as well. There was a famous case of a major conflict between the EU and the United States back in the early 2000s, when the EU did not want to share the list of airline passengers that were on flights to the United States, and the United States objected to that vigorously and got advance notices of those lists to make sure that they could check them for any terrorist connections. So in much of the same way, we're going to have to make exceptions in the cyber realm for the purpose of security.
Else, do you care to respond?
Well, when it comes to GDPR, of course, encryption is a really tricky part of that. The EU has endorsed for so long this adequacy requirement. All personal data going out of the EU can only go to a country that has an adequate level of data protection. And as a result of indeed the conflict between the EU and the US and the different views on that, and the two Schrems rulings that have come about from the Court of Justice, what companies are doing now, and this is a big concern for them, is when they rely on US-based cloud storage. At the moment, it is still a little bit unclear how encryption plays into that, whether they can use that, because the guidelines that companies are waiting for. I mean, it's a really complicated story that would take me too long to get into now. But the cloud storage connected to the encryption that companies use for overseas has led to a few local rulings as violations of this agreement of the GDPR for EU-based companies, which is quite a hassle for companies themselves.
Can I interject a question on this? Because when there are local servers being rented in the United States for oversight, I mean, the FBI doesn't have oversight of them, and they're being used to promulgate ransomware or things like that. How does that, is that seen a lot, and how does that affect things going forward?
Well, it would fall under an international transfer of data from an EU point of view. If personal data are concerned, they're exported out of the EU, then you need to have that adequate level of data protection. And the guidance that has been put out now is that encryption can be a supplemental measure, but the company that is based in the EU and that is relying on that server, that is relying on cloud storage by a US company, needs to do a check whether it falls under an adequate level of the data protection.
Thank you. I'm sorry, Michael, go ahead.
No, thanks. One other question that I thought was interesting from the ones we received prior to the program was the following on evidentiary standards. Even though there's no international instrument on evidentiary standards for attribution, to what extent do we have a transnational common understanding among allies, so allied countries or countries sharing a certain degree of rule of law principles of acceptable proof of attribution?
There's a lot into that question. I think a transnational common understanding, I don't think there is. I also think that we're talking here about a realm that is mostly secret. Maybe on the technical part, Dmitri can probably say much more about that, but from a legal point of view, especially, I'm thinking of no common understanding whatsoever. And I'm thinking now outside of criminal prosecution.
Yeah, I mean, when criminal prosecution is not involved, and in most of the cases, when you point the finger at another state, you're not thinking about criminal prosecution. It comes down to intelligence sharing. So what typically happens, and US is almost always a driver of this, they would come in and work with allies to share the intelligence. Some of it's secret, some of it may not be secret. with allies and what they think, and ask the allies to make their own determination based on that intelligence and join or not join the statements that are being made publicly. And we've seen obviously a lot of allies join in those statements, but some of them issue the statements in support, but may not necessarily point the finger, may just in some cases say that we object to cyber attacks of this nature, but not necessarily join in on the attribution.
I'm going to jump in again. How much does CrowdStrike and FireEye and how much do they share information before making attributions, or do you do it independently?
It's done independently, and those companies have their own proprietary sources that they may not always be able to share for various legal and other reasons. So just like intelligence agencies, they have their own equities to take into account.
Okay, thank you. Mike.
Let me also flag another question that I thought was interesting that talked about effective deterrence and prosecutions of cyber attacks on critical infrastructure. And I think it introduces an interesting element, right? That of deterrence as opposed to that of attribution. Is that a concept that makes no sense whatsoever in the context of cyber attacks, or is there a role for deterrence separate from attribution? And then separate from that, Dmitri, you mentioned a number of incidents on infrastructure and how cyber attacks on relevant infrastructure could really be a turning point in the US in terms of how we think of how to approach attribution and how to enforce attribution. When do we reach that point? We've seen Colonial Pipeline was a massive, I work in the energy sector, was a massive problem. You mentioned issues in hospitals. When is that point of no return reached?
Well, that's not a legal question, it's a political question. For now, the Biden administration has, I think, decided that other issues are more important. In the context of the US-Russia relationship, for example, they're pursuing not just the cyber negotiations, but they're pursuing arms control and strategic stability dialogue in terms of reduction of nuclear weapons. So they see that as very, very important. They don't necessarily want that to get derailed by cyber issues. The challenge, of course, is going to be that if the next attack comes and it's going to be hugely impactful to millions of Americans, it's going to play in the media. There's going to be political pot shots that are going to be taken by members of the opposing party, and it's going to be very, very difficult to keep it contained. That's the real risk that cyber represents in international relations. You look at the US-China relationship, in many ways it has gone sour over the last 10 years. There are many reasons for that, of course, but the first point of tension was this massive economic espionage that China was orchestrating against Western companies. From there on, the relationship deteriorated just in numerous ways. The ransomware attacks, I think, present a critical challenge to the US-Russia relationship in many ways because they're not even controllable by the state. No one's suggesting that Russian intelligence services are orchestrating these attacks. They're being done by criminal groups. But what that means is that you may have, a 30-year-old guy in St. Petersburg that's going to hold the entire relationship hostage because of an attack that they may execute against that critical infrastructure company, and they may not even be aware that that company's critical infrastructure. I guarantee you that the dark side group that hit Colonial had no idea of the implications of that attack, and if they did, they probably wouldn't have even done it because they didn't want the heat. But those things will continue to happen.
Elsa, do you want to jump in? Also on the deterrence front?
Exactly. I think there's certainly a role for deterrence here because any kind of attribution is also functioning as a naming and shaming. So simply pointing the finger at, we know you did it, we know we're onto you, we've seen your capabilities. Even if there are no consequences attached to the attribution, that can be a deterrence. But I think even prosecution in itself, and now I'm talking about the non-state actors that may be employed or endorsed by a state actor. I'm thinking of the extradition warrants that have been come out from the US as well as from other countries. They will never happen. Countries will not, in most circumstances, not extradite their nationals. And so when the US, for example, to take that example, issues extradition warrants for example, the PLA people from the Chinese hackers of a couple of years ago, they know that these guys are never going to be extradited. So in that sense, you're actually using a prosecution where you know the prosecution is never going to successfully end in a sentence, because this extradition treaty will never be there, and the extradition will never be carried out. So the prosecution in itself is a deterrence. It is also, of course, a signal to the public, we're doing something about this. So I think there's those factors that are at play as well.
Can I ask Dmitri, do you think that is something? I mean, to some extent, I'm wondering, is that a waste of resources? I mean, we spend so much money, and is it deterring anybody?
So it's deterring some people, but those types of indictments have multiple purposes. One, they have a domestic purpose to educate the American public, for example, about what is being done and who is doing it, so that you can mobilize public support for, if you're going to confront China and raise tariffs, something that you may have a lot of domestic constituencies being opposed to, you can make the case that this is why this is being done. So don't discount the political importance of those, domestic political importance of those actions. Then it has implications, of course, for allies. When you lay out these indictments, you can convince allies and mobilize support to confront countries based on that information. It also sends a message to other adversaries about our capabilities and our ability to do deterrence. So even if it does not deter the actor that you indicted, it may deter other actors that are much more careful about their public perception and do not want to be indicted themselves for any attacks. And now they will understand that the capabilities of US law enforcement intelligence community are substantial when it comes to attribution. When it comes to the actors themselves, we have seen a few cases where indictments have produced some level of deterrence. Usually it comes down to contractors that are working on behalf of the state, particularly contractors in China. When they've been indicted, we've seen them disappear off the field in some cases, because a lot of times those people were engaged in these attacks as a commercial endeavor because they were being paid by the state to do so. And they had many other commercial interests, including selling cybersecurity services, defensive services to countries all over the world. And once you are indicted, you're no longer able to do so. It limits your ability to travel, of course, without getting extradited to the United States. And given that most countries have extradition treaties with the United States, that dramatically lowers the quality of your life and ability to go on nice vacations. So it does have some level of deterrent effect against those types of individuals that have a choice to do it or not to do it because they're a contractor. If you're a government employee, if you're wearing the military uniform of a particular country, you don't really get a choice. You're executing orders, and disobeying those orders in some of those countries can have life-limiting implications. So you're not likely to do so just because of an indictment.
We have a couple minutes, so we have maybe time for one more question. And there's one question that a member of the audience posed, which is, do you see a growing sophistication in cyber trails deflecting blame to other parties? And I want to kind of reframe that question in a different way, meaning one of the features of the law is always that it's trying to catch up, right, to reality in a way. And so do we see a disproportionate divergence between the capabilities of malign cyber threat actors on the one hand, and the way the legal community or even industry, right, is thinking about cyber attribution, meaning our capacities, our malign threat capacities increasing so much more than the sophistication with which we are thinking about attribution and how attribution is being addressed from a legal and industrial perspective?
So again, from a political perspective, from a intelligence perspective, attribution has only gotten easier over time as we generate more and more digital exhaust on people and operations. Most major attacks of national consequences have been attributed very quickly. So you'd be hard pressed to find significant attacks that we don't know who's behind it. Sometimes that information is not being released publicly, but in private, it has almost always been attributed. So I don't see that trend changing anytime soon.
Alice, how about the law? We heard about the industry. So the industry is pretty much caught up.
Law is notoriously slow. So I would not be so hopeful that things would change in a matter of months, maybe in a matter of years. But at least let me conclude on a positive note. We do see a shift happening. We do see attribution becoming a little clearer. It's inch by inch rather than a big frog leap. So, but there's something happening, and that's good.
Well, I think that's an appropriate conclusion. Deborah, any last words on your end?
No, just to thank you both for joining us and this very lively discussion. I think I have some takeaways on having states actually say what the laws were, what their red lines are, and asking for clearer policy statements. So thank you, and look forward to continuing the discussion.
Thank you.
Well, then, thank you so much to our panelists, Alison and Dmitri. Thank you to all of our attendees. You will see the recording of this event online soon. So stay tuned for that, and do stay tuned for future Washington Foreign Law Society events. Thank you so much, everyone. Have a great afternoon or evening in Europe.
Thank you for having us.
Thank you.